let's call this meeting to order. Let me first take roll. Commissioner Parcells is not present. That the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive session will be held today, April 9, 2024, immediately following the session to review matters that are by statute confidential, including the review of completed investigations for the purpose of issuing final adjudications and administrative matters. So with that, we have the minutes from the January 11th, 2024 public meeting. Has everyone had a chance to review those minutes? And if so, can I have a motion to approve those minutes?
So moved.
Any second? All in favor?
Aye.
Aye. Any opposed? Okay, we have a civil penalty consent. Gordon, Commissioner Caruso.
Thank you, Mr. Chairman. There was one civil penalty case with a proposed consent agreement for our consideration. The case involves respondent Gary Gordon, who failed to timely file a statement of financial interest for calendar year 2022. Parties have submitted a consent agreement proposing that the commission find that the respondent failed to timely file a statement of financial interest for the year stated and impose the civil penalty that I will detail in my motion. After the petition for civil penalties was filed and served on the respondent, he filed his delinquent statement of financial interest for calendar year 2022. Based on my review of the facts, I'm of the opinion that this consent agreement is a proper disposition for this case. It is my opinion that the commission should impose the civil penalty agreed to by the parties per the consent agreement. There was nothing of record that would constitute a defense or excuse for non-compliance in this case. Based upon my analysis and comments, I would like to make the following motion.
Go ahead.
I move that this commission approve the consent agreement submitted by the parties imposing a $200 civil penalty for failure to file a statement of financial interest for calendar year 2022 as to respondent Gary Gordon. I further move that to the extent that the respondent has not already done so, respondent shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of issuance of the commission's order. That is my motion.
Is there a second?
Second.
Any questions? All in favor?
Aye.
Any opposed? That is approved. We have a series of civil penalty orders that are defaults. I know Commissioner Caruso is recused from the Brooks matter. Could we present the other four first?
We can.
Thank you.
4 civil penalty default cases are now before the submission for decision. Respondents involved in these cases will be identified individually. Motion I will be making with regard to these cases. These respondents failed to file statements of financial interest for the calendar years that I will detail in my motion. Respondents did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the commission should levy a maximum civil penalty for each delinquent statement of financial interests. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based upon my analysis and comments, I would like to make the following motion.
Let's do it.
I move that this commission levy maximum civil penalties against the respondents in these 4 civil penalty cases as follows. For the cases involving respondents Sierra Henderson, George Del Rio, Rena Almonte, Gregory Riedlinger, I move that this commission levy a maximum civil penalty in the amount of $250 against each respondent for failing to file a statement of financial interests for the calendar year 2021. Further, all respondents shall be ordered to file complete and accurate statements of financial interest for the year stated in 30 days of issuance of the commission's report.
We have a second.
Second.
And is there any discussion on this? All in favor?
Aye.
Any opposed? Motion's carry. We have a recusal. Do you want to state the basis for your recusal?
I believe this case may have been initiated at the time I was still the executive director of the commission, so I would be recusing.
Thank you.
Oh, after, okay, gotcha. I was way off. 20. One civil penalty default case is now before this commission for decision. In this case, the respondent Aisha Brooks failed to file statements of financial interests for calendar years 2020 and 2021. Respondent did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to respondent Brooks, the commission should levy a maximum civil penalty of $500 for 2 delinquent statements of financial interest. It is my opinion that the commission should also order the respondent to file her delinquent statements of financial interest for calendar years 2020 and 2021. There's nothing of record that would constitute a defense or excuse her for her noncompliance. Based on my analysis and comments, I would like to make the following motion. I move that this commission levy a maximum civil penalty in the total of $500 against respondent Aisha Brooks failing to file statements of financial interest calendar years 2020 and 2021. Further, the respondent shall be ordered to file complete and accurate statements of financial interests for calendar years 2020 and 2021 within 30 days of issuance of the commission's report.
Is there a second?
Second.
And any discussion? All in favor?
Aye.
Any opposed? Motion carries. Someone ask Commissioner Caruso to come back in. Am I correct that the second of the 2 lobbying matters has been removed from today's agenda?
Correct.
Okay, so we just have the administrative penalty consent for life revival.
Thank you, Mr. Chairman. There's one administrative penalty case with proposed consent agreement for our consideration. Respondent Life Revival LLC failed to timely file its quarterly expense report for the 3rd quarter of 2023 in its capacity as a principal. Parties agree that respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State. Based on my review of the facts, in particular, the considerable mitigation offered by the respondent as set forth in the proposed order, I'm of the opinion the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion.
Please do.
I move that this commission approve the consent agreement submitted by the parties and impose the following administrative penalty. As to Life Revival, Inc., one administrative penalty in the total amount of $2,500 for its delinquent expense report for the third quarter of 2023. I move that respondent be directed to pay its administrative penalty to the commission by no later than 30 days after issuance of the commission's order. My one modification would be, I believe that should be Life Revival LLC rather than Life Revival Inc. in the proposed order.
Okay. I do think the proposed order that we've seen has it as LLC, so
Yes.
good. Is there a second to that motion?
Second.
Any discussion? None. All in favor?
Aye.
Aye. Any opposed? Motion carries. All right, so now we have a number of administrative matters, starting with updates on the work on regulations. Bridget, can you?
Yes. I am happy, thrilled, and excited to report that Mary Martin and myself appeared in front of the Independent Regulatory Review Commission on March 21st of 2024 to support our rulemaking package concerning the technical regulations. After a brief presentation to IRC and answering a number of questions that they had, they voted, the IRC commissioners voted 5-0 to approve the proposed technical regulations as written and provided to them. I will say that they were very complimentary of our process. They had, I think each of the commissioners made a comment about the manner in which we chose to pursue our override or overhaul of the regulations, starting with a technical package and then moving on to a more substantive issue. So they were very complimentary. At the time that I wrote this, it had not yet been submitted to the Legislative Reference Bureau. They have now been submitted to the Legislative Reference Bureau for publication. And they are going to be, according to the LRB, they're going to be published on April 20th, and they will be effective upon publication on that date. So that should complete that process.
Kudos. That was, and for everybody's benefit, this was kind of the modernization part of what our language was, allowing email rather than fax. And we put as much as we could into the technical side, although part two, and Bridget, why don't you explain what's going on with part two?
Part two was the way that we chose to approach this. The technical regulations we could do in a type of rulemaking package called a final omitted package, which those were changes that we did not believe would get any comments from the public. No one is going to object to us taking out facts and putting in, electronic service or things like that. But substantive revisions are something that is much more likely to get a public comment. So we will have to go through the full regulatory process to do that. And we had been moving along at a fairly slow pace, if I do say so myself, but Chairman Schwartz decided, and I agreed, that we are now going to meet, and we've been meeting on a weekly basis. We meet every Friday morning at 9 o'clock, and we have been methodically reviewing each particular chapter of our regulations and going through as we go, each of us, and we've invited the entire, what do I want to say? I can say legal staff because that implies only me and Martin, but also Mary is present. Jen has been a very good contributor, and Jeff Frankenberger, while he was not on paternity leave yet, also was participating and contributing to our process. And we also invited, for the statements of financial interest section, we invited Jessica Wenger, who's our Director of Administration, to participate because that's really within her office's wheelhouse as to what they need or what wasn't working for statements of financial interest. So we have gone through essentially every chapter except for, we are still in the process of finishing the definition section, which is a little bit more complicated. We're adding some things, we're taking away some stuff, and we're modifying a few things as well. So once we get all of that finished, which we hope to do either this Friday, next Friday or the following Friday, then what I will do is start the drafting process for all of this within the bounds of the infamous style manual that I have to follow. Once we get something like that on paper, we are going to start inviting in not only the entire commission to do sessions, but also the stakeholders that would have an interest in this process, including obviously the folks from the General Assembly would be somebody that I would think would be interested. Some of the association or trade groups I think would be interested. And Chairman Schwartz had a suggestion that we also include possibly if there are attorneys that appear regularly in front of of the commission, that we might want to include them for their perspective on things that might not be working for them as well. So all told, the hope is that I will have something in writing in a draft format, in an appropriate draft format by the June meeting. I'm hopeful.
That's a lot.
It is a lot, but I'm hopeful that I will be able to get that finished. If something happens in that's not going to be the case, I will let you know, but I think
Reach out to us.
we need to set at least some sort of goal to continue moving, and I think that the chair has been vital in making sure that happens.
Just for everybody's knowledge, what we're talking about is draft changes based on input. There are disagreements among this working group, not bad disagreements, but different approaches among the working group. And you'll see in some areas we will bring to the attention of the commission where maybe the investigative division thinks it should be this, maybe we think it should be something else. This is going to be a process that once we have a working draft, we want to have all the commission's input and we want to have the public's input. So I do think it's important, and we'll see whether we can be ambitious and make the June meeting. Maybe we even think about having a special meeting that is on virtual so we can have more participation without people necessarily having to travel to Harrisburg. Maybe it's both of those things. But I think what we've heard from IRC is that the more input that we can get from people and be able to detail out that we solicited that input, potentially the easier we will have getting the approval of the final regulations. And having looked at them, there are some things in the regulations that are unconstitutional. We'll talk about them in executive session today because they turn up in a case we're doing. There are other things in the regulations that certainly can be improved. And so welcome everybody's ideas. This committee has been incredibly diligent. I want to thank Commissioner Caruso, who has also been a participant at every one of those meetings. Anything you want to add?
I would just add that I really appreciate the work that staff did, putting everything together for us to review. Their suggestions were, I think, spot on. A lot of things that I had with my red pen was marking through my copy of the regs before the meetings. I think, and the meetings have been great. And I'm going to commend you, Mr. Chairman, for keeping everybody on point and keeping us moving through. Most of the time we're limited to an hour on what we can discuss, but I think it's been great so far and much needed.
I could add just one thing. I would say that Chief Counsel for the Independent Regulatory Review Commission, along with one of their technical analysts who was responsible for the technical package, reviewing it and making comments and summarizing it for the commission members, they have both offered to sit down with me and Mary and Martin and to give their thoughts or input as to how to best proceed. In other words, are we going to do one large substantive package, or are we going to break it down into smaller packages, and what that would look like and how that would be accomplished? So I think anytime that they're offering that type of assistance, we should definitely take them up on that.
Thank you. This is an incredible accomplishment. I remember a slideshow about 2 years ago that Bridget put together, essentially telling us how impossible this is. And I think it was an effort that is still in progress, but well worth it. So thank you for that update, and thanks to everyone who has helped us on this project so far. Mary, we have a number of administrative items for you to cover.
Yes, thank you. The first item is the statement of operations. It occurred to me recently that we have not been providing the commission with detailed updates about some of the internal workings of the staff at the commission. And so I put together a statement of operations to give you a very high level about our budget, what our budget looks like in terms of our current fiscal year and prior fiscal years where we have waived appropriation funds still to spend. And so you can see that laid out in the documents. Also, the fact that we have a continuing appropriation fund available that we continue to have as sort of a rainy day fund to ensure that, you know, should anything happen, that we have unanticipated expenses, that those funds are available. I also wanted to brag a little bit about staff and the work that they do here. You can see that I have an area where we talk about our statements of financial interest monitoring and compliance. And I want to mention that just for the record here, that we have just shy of 13,000 folks who file statements of financial interest with us here at the commission. Our staff, through their diligence, has identified 1,494 people who did not file their statements of financial interest last year. And so they sent out that many first notice letters to non-filers or deficient filers. You can see that they whittled that down after that first crop of letters went out. They had to send second notice letters to 428 people, still did not file their forms. And through their efforts, again, worked that down to where we filed 45 civil penalties for delinquent and deficient filers, some of which end up resulting in the civil penalty cases that that you guys had just decided previously. So that gives a little bit of an idea about what staff, our administrative staff, has been working on. And also I wanted to provide you an update on training. We've been really doing a push to do additional trainings. Last year, we did 26 in-person or virtual trainings. We've also created a lot of materials that are just accessible to anyone. They can go online and so there's hopefully a lot more people that also saw those training materials online. We've trained in person or virtual live around 1,300 people last year on the Ethics Act. And we're really on track to do, I think, even more trainings this year. We have 19 scheduled as of the date of my memo. I'm sure we'll get more requests. Some of these folks are new. For example, Jeff Frankenberger and we taught ethics to law students at both Dickinson Law School and at Widener Law School. The rationale behind that is a lot of these attorneys end up working for the state. And so we wanted to make sure that they understood the obligations under the Ethics Act. And both of those trainings were very well received. And in fact, one of the students who is a member of the Pennsylvania State Business Privilege and Mercantile Tax Collectors Association, that's a mouthful, reached out to us and said, hey, this would be great for our folks as well. And so we have a training plan for them later on this year. And one other thing I'd like to mention is we piloted just recently a new training opportunity where Jessica Wenger and I did a training for the CEDA-COG, which is it's a Council of Governments organization for Central Pennsylvania. We did about a half an hour of Ethics Act training, and then we did a detailed training, not training, but we gave everybody a statement of financial interest form. They filled it out as we went through. And we figured, let's get it done. Let's get it done right the first time. And we've been getting great feedback. In fact, we had a follow-up request just recently for us to do this for another entity. So I'm going to try and push that, especially in areas where we see a lot of issues with statement of financial interest filing. I want to try and eliminate issues before they end up coming to you guys for decision. So we're really working hard on that. Finally, wanted to brag a little bit about our legal division, who's issued in 2023 71 advices of counsel. And so far this year, as of April 9th, 2024, they've issued 28. So I think they're a little bit ahead for this year. They're
Actually,
very busy.
It's more than 28.
Okay, so they're very busy.
They run on requests lately.
So this is a statement of operations. If there's any other information that you as the commission would like to see or have regular reports on, we're happy to do that. Please let us know.
Anybody have any questions about that? Thank you. I do think, part of our job is overseeing the fiscal operations. We always see the budget, but seeing how we spent the money is very helpful, and I appreciate you putting that together.
If I could add, Mr. Chairman, I think what Mary and the staff have done to identify some real needs, particularly in the technical area, like what we have here, what they were able to do, the budget, I think they should be commended on that. And I think Mary does a really good job with managing the funds, and, she's not a spendthrift, and that doesn't go crazy.
Thank you. Thanks for saying. All right, moving along, the next item are budget letters to the General Assembly. So as we have done in the past, we had requested an amount for the appropriation for the next fiscal year, for the 2024-2025 fiscal year. So we had submitted those materials back in September. We do not do budget hearings. We've never been asked to do budget hearings. Rather than do that, we historically have put together a letter justifying our appropriation request, sent it to a number of folks in leadership in the General Assembly and also within the executive branch, and followed up with requests for meetings, just to sit down and chat about what we were requesting and why. It was very successful last year. Commissioner Parcells was able to go with me on a number of meetings. And I'd like to replicate that this year if possible. I think it's a good opportunity to speak with people in the General Assembly and get to know them and talk to them about what we do, as well as make our budget ask. And so I've put together a draft letter as a proposal for the commission to take a look at, justifying our request. And I've included it with the materials. If any commissioners have any feedback about either the process, the people who are planning to send these to, or the letter itself, I'd be happy to hear it. But given that we have almost everyone here today, if we would be able to finalize the letter today and get your signatures on it. I did speak with Commissioner Parcells earlier today. He indicated he'll be in next week, so we could get his signature on the letter if you are all happy with the way that it's phrased and are comfortable with sending it out under this process.
I thought it was excellent. I'd move to approve it.
Any other questions, comments about the letter? So if done, why don't we circulate that letter in between the public and executive meetings, and we'll get that signed for you.
Great, thank you. Sounds good. And then after we get the letter out, I will be asking for assistance for the existing commissioners to come along with me to meetings that we're able to schedule with the leadership in the General Assembly and also in the appropriation staff. So if anybody's willing and interested, I really appreciate your assistance. The next item, titled Office of Attorney General Collections. As I have laid out in my memo, we have the commission issues orders requiring respondents to pay penalties, restitution, treble penalties. In most cases, we receive payment, but not always. And so historically, we have followed a process where when our respondents don't comply with commission orders, we would go to the Commonwealth Court and request enforcement of our commission orders. The Commonwealth Court has recently expressed, not that they are unwilling to continue to enforce our orders, but I think that they might prefer if we consider additional options in collecting some of these. We do have a substantial amount of money that is owed under our commission orders. And so I know we've talked in the commission for many years about seeking the assistance of the Office of Attorney General Collections. I was able to make a successful communication with them. We had a meeting. They indicated that under the Commonwealth Attorneys Act, their authority would allow them to engage in collection activities on our behalf. And so my request to you is the approval concurrence of us proceeding under that process and seeing if we can collect some of these outstanding amounts.
I just have a question. So
Yes.
if the Attorney General does undertake to do, where would they be doing?
So they would be doing it a number of different ways. One thing that they do is just send out a letter from the Attorney General saying that we're collecting on this. And the Deputy Attorney General that we connected with indicated that that's successful pretty often. Their other options would be to file a judgment in the county where these individuals live. And they could execute on those judgments in order to help us collect. So
So-
does that,
Yeah, so the Attorney General would not then filing in county
correct? They'd be
Okay.
doing it at the county
at the
level.
trial. Okay.
They do, just as a point of reference, they do take a 25% commission essentially off of our collections. But the money that we collect, this outstanding balance of 638,000, that does not go to fund the agency in any way, does it?
Correct. So with a very small caveat, we do have, I believe, at least one order where there were fees that the commission ordered. They were fees for prosecution and investigation. That particular case is, I think they're up to date on paying, so that probably wouldn't be one we would send to collections. The money that we collect will either go into the general fund or it will go to the local government agency per the commission's order. And I did verify with the Attorney General's office that the money can go wherever the commission has directed that it go.
As of the date of the memo,
Mhm.
over $600,000 remains outstanding. How far back does that go?
So from what I can tell, it goes back to around 2016. A lot of these cases, we entered into payment plans and stopped paying on the payment plans. So it's not that we haven't made efforts to collect this amount. Sometimes we've gone to Commonwealth Court and we've entered into payment plans as a result of the enforcement, and those are delinquent as well. So
And you made another comment, if the OAG fails to collect the outstanding amounts, they notify the agency, who can then decide whether to write off the debt.
yes.
Now, be the reason that we wouldn't be able to collect, is it because the person has moved out of state, because the person didn't have any assets? Is it, I mean, it just seems to me that it's, I'm concerned that if I have a late electric bill, which, fortunately I pay it automatically every month, but you just, you think if you get a letter from the OAG, you're going to be writing that check,
I would hope.
yesterday.
Mhm.
And I don't understand that.
I don't either.
Okay.
Commissioner.
I just didn't know if you'd heard from people or said, hey, they just said, heck with it, come after me.
Unfortunately, some people are impervious to collection efforts, and sometimes you can't squeeze blood from a turnip.
Okay.
We have cases that we haven't collected on due to outstanding criminal charges.
I know this.
Criminal charges that are related. In fact, one of the larger amounts we have not collected on because there are outstanding charges that have been filed. I'm not sure where they are in the process. It could be an issue of a bankruptcy, or they might not have any assets, or they may have passed away. So I imagine there's any number of reasons why people haven't paid. I'm sure there's some that just haven't paid.
So question, so is there any way to determine the reasons that they're not paying?
I think in some instances we know. I do. I think we've had enough communications. Our staff has really worked hard to try to work something out so that we can get some payment. I do think in many instances we have a good sense of why people haven't been paying. At least they're giving us a reason why they haven't. If the commission would feel more comfortable with us having those conversations before turning it over to the OAG, we can do it. On the smaller amounts where we're just sending out a letter, I don't know that we have a lot of those cases. So I don't know.
I would want to have a sense of that, and what type of debt.
I agree.
Yeah, I think so.
I'm also curious if you're looking to do this for all outstanding debt above a certain threshold. Because I think if we have a very large debt, we're going to then lose 25% of that amount to the OAG. In my mind, those cases may be more appropriate for us to go to Commonwealth Court and ensure that we're collecting 100%. And we may not, right? Versus a smaller amount where the 25% is a less amount. I don't know if you're looking to do it for everybody or if there's a threshold. that you're
So
trying
I think I would probably only refer the ones after we've made efforts internally to collect them. I mean, we could go to Commonwealth Court and ask for enforcement. The benefit of that is once we get a Commonwealth Court order enforcing our orders, that is apparently a judgment that can be filed in any county in Pennsylvania without having to go through the local processes. So there's still a benefit in trying it for the larger amounts, going to Commonwealth Court. We can certainly do that.
I think we need a procedure in place so that we understand what is going to Commonwealth Court and we can justify it to Commonwealth Court if they're pushing back on it, what we are referring to the OAG after we perhaps get the understanding of what the debt is. Because I don't understand what at least as of
That's a good point, just thinking through, because the balance on the other side is when you know, or when it's so small and we don't have the resources, because I'm presuming we're essentially taking attorneys or staff in the investigative division, and we may be pulling them away from new cases. But I think the suggestion is, I mean, and at the end of the day, the 25%, it's the state's money. It's really a question of, is it our resources or is it someone at the AG, and is there going to be a deferral? But putting a very basic policy together that we're going to prioritize these things. And when this fails, or we collect too many that haven't come up and it's not worth the resources, we refer them there. That may help us with the problem that we were facing in Commonwealth Court, but it also may give a good guidance for when do you get a letter from the Attorney General compared to when do you get here? And seems like, just from the comfort level of the sense I'm hearing from the commission, proposing not a very detailed, but just a basic policy that will be followed for how we decide which ones and which ones to go is probably a prudent course.
And for me, I would want some information about the debts themselves. What percentage of the $600,000 are the $50, debts that a letter would suffice for? I just don't have factual information.
Okay.
Any suggestion, recommendation, or
Let me ask you this, Mary, is there certain debt that you'd like to send to the AG in the short term? If so, should we discuss that? And otherwise, should we, shoot for June of presenting the historical information that has been requested together with a draft policy that we can approve?
But I think the debt that gives me the most, it makes me want to pursue collection at the AG's office are the smaller debts. I think it's worth our staff time on the larger ones to go to Commonwealth Court to seek enforcement there. I don't see much of a downside. It's these $250 statements of financial interest that it's not worth filing fees and the effort to go to Commonwealth Court, but that adds up and it adds up. And then all of a sudden we have a massive amount of money that's owed back to the Commonwealth for people who have not made payment. And I would want the Attorney General to go out and start filing judgments against these individuals for $250, but maybe a letter saying that we're enforcing this on behalf of the State Ethics Commission would be something that I think might help us really meet our obligation. I mean, if we're having orders issued from the commission and people aren't following them and they're ignoring them. But to make sure that they're getting like that.
I think that's the problem. I think we're just asking.
And I also,
Could the commission file a judgment against someone who owed a large debt? Would we be able to do that?
I don't know. That's a luck.
Because it would seem like if the 25% going to the AG is a large amount of money, say someone owed, it was a large restitution payment of, 50 grand. We went and put our own judgment against someone, maybe you could file it in the county court where they reside. And that would be there permanently. And if they ever tried to get a mortgage, home equity loan, that would be a bar that might motivate someone to pay. I don't know if that's possible.
I don't know that it's possible either. We need to look into it. It is outside what we're tasked to do, in terms of our statute, but it is certainly something that we can investigate.
So for today's purpose, are you seeking authorization to do anything yet? Would you like to?
I think based on the comments of the commission and the level of comfort, why don't I put together a proposed policy and provide additional information for our June meeting, and we can address this issue again.
Yes, thank you.
Great. All right, moving on. So as you all know, the commission is required to assemble and put together and post a list of individuals meeting the definition of public official and executive level public employee under the Medical Marijuana Act. We are also required to do a separate list under the Gaming Act, and we'll probably be bringing that up again next year. But we are required to do this on a biennial basis. The most recent list that we put together, we had posted back in January. It was different because for the first time ever, there had been local distributions to governmental bodies under the Medical Marijuana Act of medical marijuana funds. And as we reached out to the different local governmental entities to find out from them who might be covered under these two definitions, we got a response that they believed that their local law enforcement and some local zoning officers may also be covered by these definitions. And so we took a hard look at the definitions that were set forth in the Act, and it raised some concerns that potentially we may be underlisting people who should be subject to this law. And so we had a lot of internal discussions amongst staff. We also reached out to individuals, council at Department of Health, Office of Administration, and Office of General Counsel to talk through this. And I don't think that we have a lot of fully what's required. We were considering reaching out to the Office of Attorney General, see if they could provide us with additional guidance covered under the law. And so I am seeking the approval of the commission to do just that, which is to get additional clarity from the Attorney General's office.
Explain, there's an implication to having zoning officers and local police officers being added to this list, just so for everybody's benefit, what is the implication if you're on this list?
So someone that's on the list is subject to a number of restrictions. They cannot hold a financial interest in a medical marijuana organization. And they cannot have, and that's defined to include employment, not only for them, but also for their immediate family members. So they can't be employed by a medical marijuana organization. And there's also criminal penalties for violating that if an individual were to be included on the list. So we want to make sure that we get it right.
So we have gone in the past when we've had legal questions and sought an opinion from the Attorney General's office. I think part of the thinking here is that it appears, I think, Mary, if I'm speaking correctly for you, you believe that these people have to be listed based on the advice and some of your own views of this right now. But going to the Attorney General would give us a definitive opinion that we, be in a position to follow.
Are there additional reporting requirements if one is included on this list? Forgive my ignorance on this, but is it just a bar or is there additional reporting that we would then be responsible for seeing? And all of a sudden we've like expanded this list by thousands of people.
There is no additional reporting requirements, just that we would be required to list them and then they would be subject to those restrictions.
So the police officers, let's take that level, the municipal police officers that currently are not filing statements of financial interest because they're not at a high enough level, they still be exempt from the statement of financial interest?
It's a completely separate law, so it won't impose any additional filing requirements on them under the Ethics Act. It'll just create this restriction under the Medical Marijuana Act from having this financial interest in the medical marijuana organization.
Then they would come before us if somebody had a interest, or they would be prosecuted separately. Like,
Yes.
where does that come?
Prosecuted, it would be a separate prosecution.
So our role is solely determining who is subject to the act and then
Mhm.
listing those.
Yes, that's correct. The act also does allow individuals who are listed to ask us for advice if they're included on this list.
And how did we, so we've now looked at police and zoning officers. Are there other, folks in the municipal listing that we're just saying, there's no need, public health officers, nah, we don't need you on this list? Or, I don't understand how we've just sort of like cherry picked the zoning officers.
Well, that was what we had discussed internally as just based on our knowledge of local government, who we thought might be subject to these definitions. And it's also consistent with the reporting we've received back from the local governments, indicating who they believe within their organizations are subject to these definitions.
Just following up on a close point, should we be proactive instead of, in my opinion, just slicing and slicing and taking a look at all of these definitions? Actively, our thoughts. Having the Attorney General take a look at the list, make a recommendation to us as well. Conversation or comments.
So we could expand the request and ask it to be larger. I think the difficulty comes in because every local governmental body isn't identical. And so we don't have the same positions within every body. And so that makes it a little bit tricky for us to sort of wrap our arms around.
Do tricks. I mean, I just think
They're all
that,
different things, but essentially, every municipality is going to have a governing body, whether it's a board of commissioners or supervisors or mayor and council. And they're all going to have some type of land use regulatory body. And they're the ones that I could see would be the main ones at a local municipal level who might potentially have an interest in a marijuana facility that would be conflicting with their interest in independently conducting their municipal responsibilities. So I don't think it's that complicated. I think they're called by different names, but their functions are essentially similar across the spectrum of the grades of municipalities. And I think the AG's office is the one who needs to make that call.
I agree.
So I think the request to the AG should be who falls under this,
Yes.
including do police officers, zoning officers, or other positions. Let's ask that, or other
Leave
position
it open.
that lets the AG give us that advice.
Yes.
So should we have a motion to approve the executive director seeking an opinion from the Attorney General's office?
Do we need a motion or can we just give it direct? I mean, it's up to whatever the process is. But
What would you like?
I would like a motion.
Okay.
I move it.
We have a motion to allow the executive director to seek an opinion from the Attorney General's office on the medical marijuana list. We have a second. Any further discussion? All in favor?
Aye.
Aye. Any opposed? Motion carries.
Thank you.
Mr. Chair, if I could interrupt for just a moment.
Yes.
We are about 20, getting close to 25 minutes past the time that the oral argument was scheduled for. Do we want to allow that to take place and go back to the remainder of the public meeting, or do we want to continue on and finish up the remaining items on the public agenda and then do the oral argument?
Are council present for the oral argument?
He is here.
Okay, and council virtually participating? Okay, would it be a great imposition to ask you to wait another 30 minutes?
No, that's fine.
And would it be an imposition on investigative division if we waited another 30 minutes to complete the public agenda? Thank you. While we're waiting for that answer, why don't we go back to you, Mary, for the remaining items? Address that.
Thank you. The next item for the administrative matters is an extension of the parental leave. As I outlined in my materials, we received a letter. In fact, I think most staff received a letter in February of 2024 indicating that the executive branch had extended the paid parental leave, which was previously 6 weeks, and that they had extended it to 8 weeks. And I'm coming to you to request that we do the same for our staff. We currently offer all staff, mothers or fathers, all parents, 6 weeks of paid leave upon the birth, adoption of a child. And so I'm just asking for that extension as well for our staff.
Big man.
I think that was a motion. And I see a second here.
Enthusiastic second.
Any discussion about this? The only thing I regret is that by about 15 minutes or a couple hours,
15 minutes.
one of our employees was not eligible for this. But I do think it is a great benefit to provide in the future. So hearing any other further discussion? All in favor? Aye. Any opposed? Motion carries.
Thank you. Okay, Jeff Frankenberger is fine to wait
Okay,
until we finish.
let's finish. We may even be less than a half hour.
At our last meeting, we had some discussion regarding around merit-based pay increases. In our executive session, we had considered individual merit-based increases for certain staff. And the request from that was that we consider putting together a policy that we would have to guide our behavior in seeking and awarding merit-based pay increases. And so at the request of the commission, I put together a draft policy directive that's included in your materials that lays out the conditions and how we would request merit-based pay increases. We did model this after language that the executive branch uses. I think they call them extraordinary pay increases, but we did model it after the language. And we also did have this reviewed by our HR assistants within the Office of Administration to make sure that it's consistent with how they're handling their own staff, and that they didn't see any red flags with regard to this policy. So I would seek the commission's formal approval of this so we can begin using it.
Right. Do we have a motion?
I have one question under F, where it states in at least one rating of commendable and a job factor. Would that be things like how much work you produce and those type of, that's the job factor rather than get along with people?
Right. So to the extent you're not aware, we have a process in place where we do employee evaluations on a yearly basis and sometimes more frequently. The employee evaluation form that we use allows it has a number of different factors, including job, efforts, communication, EEO, compliance with EEO, So it contains a number of different factors and it allows the supervisor to rate each individual from extraordinary, commendable, satisfactory, I believe needs improvement and unsatisfactory. And so when we were putting this together, we wanted to have a floor. So this is the floor. So, and when we're referring to the satisfactory with one commendable, we're referring to the ratings that are in those yearly employee evaluations.
Any other questions? Give a motion to approve this policy. Motion. Diane, did we have a second? Motion second. Thank you for putting this together. Is there any comment? All in favor?
Aye.
Aye. Any opposed? No, motion carries.
Thank you.
Thank you for putting that together. I think having these written policies on kind of big picture issues is just a good organizational practice going forward. So thank you.
Moving on to the out of town meeting location. So when we had identified, I believe we did it in January, we had identified the location for our out of town meeting for this calendar year. We had floated a number of different ideas, but we had settled on, or we had tentatively settled on Erie, Pennsylvania for the location, mostly because we've never been up to northwestern Pennsylvania for a commission meeting. As you know, yeah, now we know why. As you know, we're required to have one out of town meeting per year per statute. And so when we started looking into the cost, and particularly the transportation costs, we realized very quickly how expensive it was going to be for all of us to get to Erie for this meeting. And given the capability to attend meetings virtually that we have now, really anywhere we hold a meeting, we thought it might be a good idea. Actually, the chair thought it might be a good idea to look at some other options. So Julie Gibson had served as our travel agent and had priced out a number of different options for consideration by the commission. You can see that they're laid out in the Excel spreadsheet that was attached in the meeting materials. I will note that this doesn't include every single expense. These are the variable expenses, like how much it will cost for everyone to travel to the location in terms of mileage, hotel expenses based on each location. So I would leave it to you if you have any questions about these different locations, but I'd leave it to you or ask for your comments or feedback about what you would prefer.
Gettysburg. Because it seems like it's pretty cheap.
If I may, I think we started earlier by talking about training and our opportunities. And I really love the idea of having something at the law school of Penn State early in their semester, and potentially tack on a training session for either their government students or the law students. I think that might decrease the cost of doing it in the law school and having people come and see. I mean, it's wonderful to have it here and we get a handful of people, but I do think that we could do some outreach on our own to professors we know there, to try and get some youth or others in the room. And that's exciting to me. It's the idea that this should be an open and transparent proceeding and invite students in. I have a very strong preference for that. Not that I don't like Gettysburg being cheap.
No.
And I defer to the vice chair, but I don't know that the difference is so incremental that benefit and allowing you to do training while you're there.
I'm not opposed to it, but I'm just cheap, so I'm just, I mean, that's.
Other thoughts? I think
I think that's a good idea.
That's a really
actually.
good idea, but other thoughts, whether it's State College or anyone else on this
And
list?
you can't talk because you're from Penn State, right? You're a Penn State.
Undergrad, I don't think I have to recuse. I don't have to answer questions. Although I would note, and I saw a note on here, if there was any way to get at the Dinty Lion Inn and be able to do that together with the law school, the hotel that was on there in Bollesburg is a little bit outside of being able to walk to places. So I don't know if it's going to be a substantial price difference, but if we were able to get an organizational rate and be at the campus, I think that would be better.
Yeah, I agree. And Julie has been she's been in communication with the owners of the Nittany Lion Inn about getting a state rate. I don't know that you've gotten that yet because they haven't reopened. They've been closed for renovations. But once we're able to get some more information from them about the rate, we can certainly consider that as another option.
So can you just explain, I'm sorry, I'm not familiar with State College and state. So what what I'm hearing is that Bollesburg is State College? or-
No, Bollesburg's about 10, 15 miles from
Yeah,
State
about 10 miles
College.
down.
Maybe
Yeah,
about
okay.
10, yeah.
There's also the Penn Stater that,
It's not available. I looked at it.
okay,
Yeah.
okay. And then there was also a Hyatt, I think, that recently opened up.
And there's a new one, the Graduate, that opened.
I did see that. I think it
That might
was,
be pricey though.
yeah, I think that was the issue. I saw that one as
Yeah,
well.
I think we want to be fiscally responsible here. So, well, any other thoughts, or is there a consensus around State College and trying to combine it? I guess even if we stayed at Bollesburg, if we ended up doing the meeting, if we could impose and do the meeting at the law school and open that up, if they have a public area, that would be terrific.
And how far is State College? Do I have to drive there?
From Phil, yeah, unfortunately, there is no train to State College, and it's about 3 to 3.5 hours from
So who's
Philadelphia.
driving? I'm not driving.
You can drive with me.
Okay, as long as you drive.
Or I.
There is a small airport, but service may be about once a week
No,
in Philadelphia.
It's okay. It would be a puddle jumper.
I assume the drive's okay for the other commissioners?
So you can take mine off, because I'm always on.
There you go.
No drive with one of us.
Yeah,
Okay, well, it sounds like the guidance appears to be State College, and if there's a way of getting a hotel in downtown State College rather than Bollesburg, that would be a preference, but if not, I think the absolute preference, and I think it's a great suggestion, is incorporating the law school. And, even letting, other people on campus know we're doing this, whether it's the local newspaper or, some of the undergraduate government classes to
Sure. We're
try to
happy.
get some attendance.
Sure, that sounds great. We'll also reach out and see if we can schedule a training and we can offer it to anyone that's interested.
Terrific.
There you go.
So I think the last item of it on the agenda for today's proceeding is public comment. Is there anyone who would like to offer public comment for the regular meeting? Hearing none, I'll entertain a motion to adjourn.
second.
All in favor?
Aye.
So we stand adjourned.